Hello. Because we don't want it that getting to the farm. Has to move on.
Unlisted today.
Yeah, but it's still emergency. The 75 years old lady being harassed by the police personnel from 24. Very urgent, extreme urgency.
He's being harassed by the police.
Yes,
Since when he is being harassed?
Since December.
Since December, she has been being harassed.
Yes,
And now today, on the last date, you have got the chance to move this matter.
Mr. Binu Kumar has to appear in this matter.
Advocate is not later on. I am talking about the Mary.
Yes, madam.
Okay, first Mary. Then the person will come.
No, he has given a lot of complaints against that police person, but no steps taken by the Director General of Police.
What matter you have want to say? What is police in action?
Yes, madam. There is a land dispute between the two private parties.
But the land dispute in between the petitioner and private party. What is the urgency?
Private party means that petition respond number 5, and in between there SHO PS Kalighat. He is interfering this matter and is taking.
So what is the urgency that today High Court is to interfere?
Minor.
No such urgency. You file it.
I have to call my.
No such urgency. In judgment.
Michael Marks, we have 56 of 24.
Lordship, I am for the petitioner.
Where is Mr. Prasad? So, after discussing all the issue raised by you, both of you, ultimate decision, the 2 points was determined whether a revision lies. This question has been answered in affirmative. Even whether the proviso of section 125(3) creates any bar on or restriction on the enforcement of the maintenance order under such and such. It has also been answered in negative, but since you have slept over your right for a considerable period of time and delayed, caused delay in asserting your right, did not approach the time within the prescribed period of limitation. ঠিক আছে? No remedy can be given under the code. However, this order will not preclude you from recovering the area of maintenance by availing herself of the remedies available under any other act. Go to the civil forum, nothing can be done. Okay. There is no other provision for recovery, areas of recovery of money in the code.
Same matter.
Same order.
Item 3 also same matter.
Okay. Why are you so hurry, huh? Same order.
Much obliged.
Hmm. But you have output good. Your advance good or good. But it is a gray area what can be done. Yes.
Item 4, WPA 6.4 with WPA 6.6.
Please, Lordship, I'm appearing for the petitioner in serial number 4 and 5.
Yes. Yes, court have accepted your contention and the order passed by the learned court below, both the court below are set aside, and the applications which are dismissed are revived with a direction upon the learned magistrate to consider the same in the light of the observation made in the order.
My lord, the only one difficulty is that the case is already disposed of.
Cases is disposed of.
Yes, he is convicted. So,
No.
my lord, may I?
Case cannot be disposed of. The case at least may be filed for the present. Actually, warrant of proclamation and attachment could not be executed. The case would be filed for the present.
No, accused is convicted. Therefore, the case is disposed of. By final judgment, accused is convicted. Therefore, I am praying that as per prayer clause D of my present petition, my lord, if it feels appropriate to your lordship, then my orders may be passed as per prayer clause D of my present petition, lordship. Lordship may have a look at my prayer clause D once.
So here you have challenge here that since the accused person could not be brought to the court in execution of warrant of arrest and subsequently even warrant of proclamation of attachment, you made an application to issue a direction to the concerned police authority to initiate a case under section 174A and 229A. That was rejected.
Yes.
Citing that the warrant could not be executed, report has not been submitted. Okay, court accepting your contention that both the offences are stand-alone offences, and the case cannot be set without waiting for the submission of execution report, and accordingly order has been passed. Okay, that issue was only for consideration before this court.
Yes, lordship.
Generally, if the accused person remained at large and he could not be arrested during a trial, then generally the case is filed for the present. And as and when accused could be arrested, then the file is reopened. Okay, that is the matter to be looked into by the trial court. Okay,
Very well, lordship.
which was raised before this court, that has been dealt with accordingly.
Very
Okay.
well, lordship. I am grateful.
Okay, next.
Item 6, WPA 11 of 2025.
Yeah, give me the list.
Your Lordship, in this matter, Mrs. Das is appearing for official respondent, Your Lordship. I pray for short passover, Your Lordship.
Upon the private respondent, it's not paper. I pray for next petition.
as paid for um, on behalf of the private respondent, ঠিক আছে, comma, list the matter in the next circuit bench subject to his convenience.
Okay.
Hmm.
Item 7. Item 7, WPS 64 of.
Here, there is an urgency alert from 6th and moving alert. There is an urgency
Ah.
saying that the appealable order cannot be passed by the SDO against the.
Whether final appeal has been or case under section 161 has been finally disposed of or not.
Because I have
Ah.
received this.
Where is Mrs. Das? Miss Das?
Like before court number 1, your lordship, I prefer short pass over your lordship in this matter.
Huh?
Short pass over your lordship.
Okay, pass. Pass over.
Item 8, WPS 69 of 125.
Here also, my lord, I am appealing to the petitioner. Here, my lord, the petitioner has given a representation before the authority, Tahsildar for mutation. But my lord, some steps has been taken, thereafter, my lord, it has not been completed. Mutation proceeding has to be completed within certain time. That has not been done. My lord, kindly see, my lord. It's on the basis of bill. I am praying for mutation, my lord. It was the,
Bill,
on the basis
someone
of
to
bill.
appear particulars of the right, right acquired. What application you have, for what purpose?
Mutation of my land on the basis of the bill, registered bill. Thereafter, my lord, Form J and Form K, which is mandatory. Once I have filed an application before the Tahsildar for mutation, Form J, summons to appear and summons to interested person. That has been done. It has published, everything done. Now only the order has to be passed, opportunity of hearing has to be given and order has to be passed. That is not done. From 6/11/2023, my lord, that's why I have come before this court. Passover may be given, your lordship.
Pass over.
This can be disposed of.
Yes, it will come.
Item 9, CO 61 of 2024.
Your lordship, this is that case, your lordship.
Hmm. Which case?
Reconstruction of the record.
Oh,
This is the order which was passed. My junior noted down, I got it typed. The position is the same. This is going on for last 3 years.
okay, now. Excuse me, title suit number 64 of 2024, 23. The record of this title, 2003. The record of this title suit is missing.
Yes.
Oh, title suit is still pending.
Yes, because I filed the application for appointment of commissioner after the preliminary decree was passed.
Oh,
I filed the application for appointment of commissioner.
that means the preliminary degree was passed.
Yes. This traveled up to this honorable court. Decree was modified subsequently by this honorable court.
Oh, appeal was prepared.
Yes,
Degree was modified.
modified.
The number of the appeal?
Your lordship, it's there. I have annexed all the documents.
Oh.
Just a minute. Okay, I could order it. Yeah.
Title appeal. One title appeal was filed, title appeal 26 of 2010.
Yes, it was just 1 minute.
Now, whether intervention of this honorable court was sought for,
Yes, sir, second appeal was
Yes,
filed,
yes.
it was modified.
Yes,
It
I'm
was modified.
giving it.
Oh, second appeal was filed.
Yes,
Number of the second appeal,
giving it. 2 of 2015.
2 of 2015.
15.
The order has been annexed or not?
That
Order is not that.
Okay.
I have it. I have the
Oh,
certified copy.
give it. And Honorable, take it. This instant petition has been filed at the instance of the plaintiff petitioners under Article 227 of the Constitution of India, throwing a challenge to the order dated 30th October 2024, passed by the learned civil judge within bracket senior division at Sri Vijayapuram in title suit number 64 of 2023 within bracket Srimati Muna or Begum versus Sri Asif Ali and others. By that order, full stop, by that order, the learned court directed the record keeper class in charge district record room to place the original case record of title SOITS 64 of 2023 positively on the next date. Stop. Record reveals that next date was fixed on 11th November 2024, and I am told that on that date also similar direction was given upon the record keeper concerned. Stop. Mrs. Nak, learned senior advocate, representing the petitioner, submits that for the last 3 years, that somehow the record was misplaced from the record room, and for the last 3 years, and such fact was brought to the notice of the court. But for the last 3 years, similar type of orders are being passed.
Sir, there is no whisper in the order that record is misplaced. That language is not used. Only direction was issued upon the record keeper to trace out the record and place it before the court. There is no report for that record is misplaced. There is no such report.
They are not doing it. What can be done? Kindly see your.
It is her submission. Okay,
It's my submission.
Acha. She prays for an appropriate direction upon the learned code below to reconstruct the record.
Yes.
Stop. Mr. Prashant, learned advocate, representing the
Respondent number 1 and 2.
respondent number 1 and 2, opposite OP number 1 and 2, OP numbers 1 and 2, submits that there is no reflection in the order of the learned code below that the case record was misplaced. Stop. Now, before going to delve into the contentious issue raised in this petition, it would be appropriate to narrate the essential facts leading to this petition. Stop. Actually, the plaintiff petitioner filed this partition suit being petition being TS 64 of 2023. Stop.
2003.
2003, stop. Achha. And after appreciation of the evidence brought before the court, one preliminary decree was passed declaring the share of the co-sharers of the land, suit property. Stop. And the said preliminary decree was assailed in an appeal being titled appeal number
26 of 2010,
20
page 41.
लिख दीजिए title appeal number 26 of 2010, which was disposed of by an order dated
31/10/2014.
31/10/2014. However, challenging the said judgment and order passed in the appeal, one second appeal being SA 2 of 2015 was also prepared before this court, which was also disposed of by modifying the preliminary decree passed by the learned trial court. Stop. Then you file application.
Yes, order
Achha.
26 rule 13 for appointment of commission.
Thereafter, the plaintiff petitioner filed an application under order 26 rule 13 for appointment of partition commissioner, but the case record of title suit such and such could not be recorded and could not be located.
Order dated, Your Lordship, page number 72, Your Lordship, may kindly come.
When you filed that application,
2021.
filed this application in 2021. Thereafter, case could not be located, and despite the matter being brought to the notice of the learned court below had passed as on several occasions issued direction upon the record keeper in charge of the district room to produce the case record before the court.
District record room.
District record room, district court room, what's your district record room?
Record keeper / in charge record room.
Stop. Achha. A judicial institution is committed to deliver objective and swift justice to the people. Stop. And it is unfortunate that one case record of one partition suit in which preliminary degree has been passed with other follow-up actions left to be completed. Such file has been somehow missing and from the courts below, and for the last 3 years, no effective business has been done in respect of that case. So, and accordingly, the logical conclusion could not be reached for this reason. Stop. However, it has been brought to my notice that the next date of the suit has been fixed on 25th February 2025. Taking note of this fact, that this revision is disposed of with a direction upon the learned court below that if on that date, that is on 25th February 2025, the case record is not placed before the learned court below, the learned court below shall take all necessary steps for reconstruction of the case record as per the prescription made in the civil rules and order of the Calcutta High Court. ঠিক আছে? And it is expected that the parties hereto shall assist the court in reconstructing the aforesaid file by supplying the documents which they have in their possession.
Plaintiff has already supplied.
Pleadings and or pleading document, say pleadings and orders.
Certified copies.
Your Lordship, this is the
certified-
bunch which I have already submitted to the court.
Oh, okay.
Complete certified
ঠিক
copy has
আছে।
been submitted.
And the learned court below is further directed to further direction is required.
That is enough here.
Huh?
My lord,
Enough.
this should not be as a precedent because no record should be misplaced from the court. If suppose he is not having certified copy, what will happen? Just imagine some other cases.
Yes.
So this should
Yes,
not
thanks.
happen. So therefore, my respectful submission before this court is that a copy of the order be sent to both district judge as well as civil judge senior division. Trace out their record.
আচ্ছা, should not fix the responsibility, should the locate should locate the person who was responsible for the misplacement of the record and fix a responsibility and take steps in accordance with law.
Here.
ঠিক আছে? Let a copy of this order be sent to the learned court below as well as to the learned district judge
For information and complaints.
for their Andaman. ঠিক আছে?
Here. Deeply obliged.
With this observation and order, there is the last part required to be given. Then one disciplinary proceedings. See, yes, it is going on. Okay.
Obliged.
Obliged.
Yes.
I am for the petitioner. It is
Yeah.
electricity matter. My client has filed application to the authority for obtaining electricity.
Lordship, I am appearing for the respondent, Lordship. Let this matters go to the next
Same
circuit.
matter. Same direction.
No, Lordship. No, Lordship. Let this matter go to the next circuit bench. Lordship.
Oh,
Only
Item number 10 and 11.
on earlier
I
occasions,
intend only direction upon the authority to dispose of my petition. Why next circuit, sir?
take decision. Take this.
Lordship, they have not served the department, Lordship. So let it be in the next circuit bench. Let them come. I will not oppose them.
Sir, I will supply you the additional copy. Only I intend only direction upon the authority to dispose of my application and nothing.
Lordship, let it be in the next circuit bench, Lordship.
Take decision. If court does not say how you will take decision. You
Lordship, they have not served the copy, Lordship. That is the problem.
At the time of call, learned advocate, you are from the petitioner. At the time of call, learned advocate, where is Mr. Jafar?
another person has joined.
Let it go to the next circuit bench, Lordship. After 7 days, next circuit is coming.
I have not filed, but proof is
10
there.
and 11, let it go to the next circuit bench, Lordship.
At the time of call, learned advocate representing the petitioner has paid for accommodation. You have been sent for notice.
10 and 11, Lordship.
See the
Learned
sir,
advocate for the
Deeply obliged. Deeply obliged. 10 and 11.
Support the learned advocate.
only.
Learned advocate represent petitioner.
If you can to pursue your, I am ready to pass the order, but he is saying
Only required.
The second week of the.
I have said the amendment.
look, try to
10
pass
and 11, let it go to the next circuit bench, Lordship.
Like,
the next circuit.
Obliged, Lordship.
Yeah. As paid for, as paid for on. Lordship,
Lordship, I am appearing for the response. No copy has been served, Lordship. Let it go to the next circuit.
got it. Place next circuit, huh? 11 also same.
Service in the category.
Seen it. Criminal appeal.
Actually, I would be appearing on behalf of victim girl. So I have filed my vakalatnama as well. Victim was also served. It's a POXO case. And the state has come up for enhancement of the punishment.
But none appears.
None appears for the,
So next circuit, what can be done?
since he has been served, I believe, the accused, who is in jail. If he is not represented by a counsel, so a counsel from SLSA can be appointed for him.
The appellant shall produce the document showing such service.
Service, correct.
Huh? If they have service. Who is for the appellant?
Appellant, Leonard Counsel, Mr.
Achha, none appears to represent the appellant, though Miss Mini, learned advocate,
No, Zinu.
Jinu, learned advocate, representing the victim girl, representing the victim is present. Stop in view thereof. List the matter before the next circuit bench, comma, subject to his convenience.
The appellant's counsel's absence may not be recorded because he's sick. That's the reason he has asked me to mention on his behalf also.
Or you could have asked to.
His absence may not be
Achha,
recorded.
so put, and accommodation has been sought for on behalf of the appellant.
State killing, victim. Yes, and
Appellant. ঠিক আছে, though Ms. Jinu, learned advocate, representing the victim is present. Stopped. আচ্ছা, in view thereof, next circuit.
okay.
List the matter before the next circuit, comma, subject to his convenience. Next, 13.
Despite service, nobody is appearing here actually in this case. What is to be done? No, she's with me.
Oh. What can be done? Next circuit. আচ্ছা। আচ্ছা, despite service, the respondents are unrepresented. ঠিক আছে? না, respondent is unrepresented. আচ্ছা, stop. আচ্ছা, in view thereof, to afford another opportunity to the respondent to appear, list the matter to appear, comma, list the matter before the next circuit bench. ঠিক আছে? Before the next circuit bench. Stop. Where is your learned friend? Miss Mini, why is your learned friend missing?
In both the matters, she's there. One matter is there is an extreme urgency, my lord, I think, because on 14/2, there is already notice has been given for demolition. 14/2 is the date.
So, would it be proper to wait for her? Okay, yes. Oh, it's just come. Yes, Ms. Das, whether finally disposed of 161 proceedings.
my lord, this private respondent, my lord, she has filed an appeal against the stay order, my lord, before the
Against the?
SDO, before the SDO,
Stay.
stay, my lord.
That means
After-
has not finally been disposed of.
Finally disposed of on, my lord, thereafter, after the SDO passed an order, my lord, thereafter Tehsildar passed the final order, which is, I don't know whether it is annexed or not.
That order we have.
5th February 2025, my lord. That is the final order.
But how
Yes, my lord,
he
that
is
is the
saying
question.
that how?
Opportunity of hearing was not given. If my lord can dispose of this matter, my lord, remanding the matter back before the Tehsildar to decide afresh after hearing both the parties.
No, no, that has to be done.
That can be done because
compliance-
since she is a destitute lady, maybe this private respondent, my lord, she is a handicapped lady or something like that, and she approached before the SDO. And SDO, she's a new, she has just taken the charge. She didn't know about the earlier proceedings. So when she approached before the SDO, my lord, after seeing the stay order, she proceeded with the matter and directed the Tehsildar to pass in final order. This is the final order, which is on 5th February 2025.
This cannot be passed because.
What was the stay order passed by the Tehsildar?
Stay order, my lord.
Have you annexed?
that is-
Stay order 22,
My lord, that is.
page
on
22.
21, my lord. Page 21 is the stay order, my lord.
Or page 21
21 and 22. Both.
and 22.
22. 21 is the order, my lord.
So, yeah, one interim order was passed in a 161 proceeding, restraining you to make further construction.
My lord.
But
There-
Okay.
since
there
they
are
Challenging the said.
because even after the stay order that has been granted by the Tehsildar, my lord, despite of that, my lord, they were continuing with the construction work. So this lady, this private respondent, she approached before the SDO. So SDO has passed an order. On the basis of that SDO's order, Tehsildar has finally passed this order on 161.
May I make submission?
That is on 5th February
After the stay order,
2025.
my lord, the report was called for, my lord. That is, kindly see, my lord, report was called for. That is at page 24, 25. Thereafter, my lord, 26, 27 is the order sheet of the Tehsildar. On the basis of 28, report of page number 28, a compliance report has been given because after the report, it was found that I have been encroached some portion of land of the private respondent.
You have
That-
been good.
I have been encroached. What I have done, kindly see page 29, my lord. As per that order, I have demolished that portion. I have demolished it. Kindly see, my lord. Paragraph 1 says,
Now you have demolished 12 hectares such and such. 0.0. I can recollect. But later on, it was detected, you have still encroached 23.
kindly see, this is the thing I have made. There are
Ah.
four.
Most probably there is a satisfaction of encroaching the
now-
land of the others.
Now, my lord, now only
What is this?
square meter left out, 170 square meter out of 200 for me. 170 because as well as they are saying this much have to leave, I'm leaving again coming back. Now I'm seeing only 170 left out with me.
Although
200 is there.
200 was allotted to it.
I have mentioned first, second, third, fourth. First one is the Mohammed Bashir's order. As per that report, I have demolished. That is the second report of Mohammed Zakir. The third report of Parminder. That both are same. As per that, I have demolished. I have constructed once again. Now the fourth person came and he is showing this much land again. Well, how many times have we demolished and I will construct? Before construction, I have given a letter for demarcation. After demarcation only, I have started my work. Then the lady approached before this court. Then I said, okay, 12 square meter, I will demolish that portion, I'll come to that. Then again, now she is saying no, again. How can it can be made? My client, he is a petty vegetable seller. This is the thing. Seeing his handicap or something like that cannot be done here, my lord. That cannot be done. Now with me, only 170 square meter left. So what I say, my lord, opportunity of hearing should be given and fresh demarcation upon my land and as well as her land. Mine is only 170 now. Mine is only 170. I'm saying if If I'm more than 200, then I'm ready to demolish the another portion also.
Okay,
I'm ready to demolish. Now I'm only having 170. In that also they are saying it's their land.
okay.
My lord, private respondent is not before your lordship.
My lord, I have filed the affidavit service. It has not been.
That
served.
is the
It
thing.
has not been served.
That's why
What?
Because, my lord, kindly see the draft report as well as because on 6th I have served first copy. Before the day which I have.
Item on hold, address cannot be
That
located.
is the first one. Next again, after this order, my lord, after passing my lord's order on Friday, I have served again. It is only because yesterday was holiday, Saturday, and here, my lord, private courier is not accepting the local delivery, my lord. I have went to 4 couriers to deliver it. But private couriers, they are saying no, they are not taking the local delivery. That is the whole difficulty, my lord. As per the direction, I have immediately through speed post, I have sent it, my lord. I have sent it. My lord, opportunity of hearing should be given to the lady also before the authority. That has to be done. But what the SDO has passed, that is an illegal order, my lord. That cannot be passed, my lord. Because law says against the original order. Only the appeal can be live. So here original order is not there. Stay order is there. On the basis of that cannot be done. It's an illegal order. It's a perversive order. So I have to go before the Tehsildar only. Before the Tehsildar, she will get the opportunity, my lord. And the demarcation has to be done, my lord. My prayer is there, both the land, my lord. Her land as well as my land. If I want anything, my lord, I am ready to. What is there, my lord? Because I'm the vegetable seller. He doesn't want beyond the 200 square
The
meter.
legality of the order dated 3rd February 2024, passed by the subdivisional officer. Directing the Tahsildar to evict the illegal structure constructed by the petitioner upon the land bearing survey number 1210, situated at Kalikot village, has been called in question. During pendency of this petition, where is the 5th February order? Pursuant to the order dated, pursuant to the order dated, pursuant to that order, Tahsildar passed an order on 5th February 2024, directing the petitioner to vacate unauthorized occupation over the land, inserting a default clause therein that in the event of his failure to do so, the such unauthorized occupation shall be removed by the revenue officers and the materials will be confiscated on 15th February 2025. Stop. The order dated 5th, stop. Miss Meaning, learned advocate representing the petitioner submits that based on an application filed by the private respondent, namely Srimati A. Gomati, a proceedings being RC case number 1961/TSVP/2013 was initiated. Stop.
23.
And 2023, sorry, 2023 was initiated, and one interim order was passed therein.
Stay order.
Stay order was.
Acha, and one stay order was passed in the past, acha, to stop construction work passed therein to directing the petitioner to stop a construction work upon the land till demarcation of the land. ঠিক আছে? On
Stay order page 22, my lord.
21st August 2023. The petitioner made an application for vacating of the said stay order. However, Srimati A. Gomati directly approached the subdivisional officer concerned with a plea that despite the stay order being passed, the petitioner went on making further construction on the said land. The subdivisional officer intervened in the matter, and by an order dated 3rd February 2024, concluded that the petitioner has illegally occupied an area of 23 square meters out of survey number 1210 by constructing a RCC structure thereon, and that SDO concerned in his order stated that in exercise of its power vested in him under section 28 and 32 within bracket 3 of the such and such regulation 1966, he directs the Tahsildar concerned to remove the illegal structure constructed by the petitioner. Being so directed, the Tahsildar disposed of the said proceedings, the concluded said proceedings by an order dated 5th February 2025, without affording the opportunity of hearing. By passing an order dated 7th February 2025, this court requested Ms. Das to take instruction in this matter. Ms. Das submitted that the proceedings initiated under section 161 of the regulation was disposed of only by the order dated 5th February 2024 in compliance with the order of the subdivisional officer concerned passed on 3rd February 2020. As per the regulation 21, a appeal is 28, an appeal is provided only against the final order passed in proceedings initiated under 161, under section 161. So, now, the Miss Gomati approached the SDO concerned during pendency of the proceedings being RC case number such and such. And without taking note of this fact that the said proceedings is pending for consideration before the Tehsildar, the SDO concerned passed the order on February 2025. Stop. Accordingly, since the said order was passed not according to the regulation, that the same is fraud and cannot be allowed. Same is fraud, FLAWED, and the same cannot be allowed to be sustained. Consequently, the order consequential to that order, consequently the order dated 5th February 2025, which was an order passed pursuant to the order dated 3rd February 2024, is also void, stop. In view thereof, both the order passed by the SDO concerned on 3rd February 2025 and the 5th February and by the Tehsildar concerned on 5th February 2025 are set aside, stop. And the learned Tehsildar concerned is directed to conclude the proceedings after affording opportunity of hearing to all concerned, including the private respondent hearing, and after considering all aspects, within a period of
3 months. It will take some time.
And who will demarcate? He will demarcate.
Tehsildar will.
To demarcate. Both the land has to be demarcated. My prayer is also there to demarcate. First demarcation has to be taken place, and thereafter
They will inspect the property.
And the Tehsildar make a sincere effort to fully resolve the issue by making demarcation of the land of the petitioner as well as the private respondent. And it is made clear that a report shall be made to make this determination in presence of both the petitioner and private respondent. With this observation and order, this petition is thus disposed of. However, there shall be no order as to the cost. Any time has been
case number is mentioned.
It is made clear that entire exercise shall be completed within
because stay is there, never mind how the construction is.
Around 1 month. It will take some time, my lord, around 2 months.
2 months.
Because demarcation and everything has to be done.
2 months, within 2 months.
Dispute.
At this time, this exercise shall be completed perimetrally within 2 months from the date of receipt of a copy of this order. Next time.
My lord, if there is one line, my lord, since despite of service or private respondent is not before my lords, because private respondent. Because
that 28 is not applicable. SDO cannot go beyond the law.
there are procedural lapses there, my lord, that I do accept, because being a destitute lady and she is handicapped also, they proceeded with this matter, with her application. She has just filed before the SDO that look, despite of the stay order, they're still continuing with the construction. So is due on her application.
And,
notice to
yeah,
proceed.
you add one submission. Mr. Mini submits, Miss Mini submits that if the petition, this petition is disposed of by directing the Tahsildar concerned to conclude the proceedings after affording opportunity of hearing to the all interested persons, stop. The private respondent will not be prejudiced. ঠিক আছে? হ্যাঁ, you write this thing, thereafter I shall.
Obliged. Obliged.
Yes,
Item 8, WK 69 of 2025.
So here I'm referring to the petitioner, my lord. Here,
I am for the respondent.
my lord, here, the petitioner has made an application before the Calcutta on the basis of bill executed by his father for mutation. My lord. That is at page, my lord, 15, my lord. Page 15 is my application, my lord. On the basis of this, my lord, already a Form J is the notice of mutation to interested person. This has to be issued, my lord, as per the land revenue rules. And this was issued, my lord, 15 days time was granted. Thereafter, my lord, Form K was issued. Kindly see next page is the Form K, my lord. Summons to appear. This was done on 4/7/2024, my lord. But the final.
Form J was issued to the interested person.
Through all the
And
legal
Form
assets.
K also.
Here is the notice, after 15 days, my lord, we have to wait. Thereafter, summons to appear, Form K. That was issued on 4/7/2024.
Okay.
Thereafter.
So I'm directing them to conclude the proceeding.
Now the hearing has to be done, order has to be passed.
Acha, yeah.
Opportunity of hearing to be given to all the interested parties.
This present petition has been instituted seeking a directive upon the respondent number 2 to mutate the land bearing survey number 76/2 comprising an area of 2000 square meter, as 200 square meter situated at such and such village at under Port Blair Tahsil district, South Andaman, ঠিক আছে, in favor of the petitioner as per the registered will. ঠিক আছে? Stop. Ms. Mini submits that upon receipt of such application, the follow-up actions, including issuance of Form J and K, Form K was were taken, but thereafter no effective step has been taken to conclude the proceedings. She submits that appropriate direction be given upon the concerned respondent to expedite the disposal of the proceedings. Stop. Acha, Ms. Das, repenting the respondent submits that if such direction is given, the respondent shall not stand in the way. Stop, toucher. She shall have no objection. Stop. Acha. Having heard the learned advocate repenting the parties and upon perusal of the materials on record, stop. The writ petition is disposed of by directing the respondent number 2 to conclude the proceedings initiated based on the application made by the petitioner dated 6/11/2023 within a period of 2 months from date
2 months it is required
Huh?
because all 7 legal heirs are there. Whether there are any objection from any other side.
Objection is there.
So all the
notice
parties
period
has to be heard, my lord. It will take
Okay,
some time.
he has many other job also except doing your job. ঠিক আছে? Within 2 months from the date of receipt of a copy of this order, after opportunity of affording opportunity of hearing to the all interested person. ঠিক আছে? Is there a possibility that any order can be passed against you? Huh?
No, all the legal as they know, because the father has given.
Tehsildar should know after hearing, at the time of
Oh.
hearing
Yeah,
only,
yeah.
because first they will have no objection. At the time of hearing, they will object on the will. Whether the will is disputed, my lord,
Hearing may be given to all the parties so that it can be.
because it's a question
Okay,
of
with this
will.
observation and order.
Obliged.
My lord,
Yes.
I'm sorry, my lord, at the time of mentioning, I was not there. My lord, a writ petition, my lord, there is an extreme urgency. Since, my lord, my possession, which I am holding from 1960 onwards, the Tahsildar and Station House officer in connivance with a private party, my lord, who claims to be the owner of the said land, my lord, are frequently interfering with my possession. And in the said process, my lord, I have annexed the photograph. I am presently aged about 75 years. My lord, this is a case of Diglipur, my lord. My client came all along from Diglipur, my lord. Now, my lord, I am seeking for an interim order directing them not to interfere with my possession. I can demonstrate from my writ petition that I am holding the possession from 1960. What happened, my lord? In the year 2022, the private respondent started to interfere with my possession. On wrong legal advice, she has filed a suit for adverse possession. Now, when she filed the suit for adverse possession, she did not get a decree from the court and the suit was dismissed. The moment suit was dismissed, the SHO and the Tahsildar, in abuse of their power, my lord, one after another illegality they have committed, and they are making all effort to remove me from the entire land. And in the said process, even they demolished the structure which was standing in the land. These all are there in my pleadings, my lord. Now the question is that, my lord, if suppose I lost a suit before any court of law, where I seek for certain relief. Now, my lord, the question is that whether the executive can execute the order when the party did not file any suit for my eviction and recovery of possession. My suit for adverse possession was dismissed. Thereafter, this executive, that is the Tahsildar and SHO, are making all effort to remove me from the said land. And, my lord, there are orders of Tahsildar. He issued orders. There is no law whereby the Tahsildar can execute the order of the court. And even the other side has not filed any suit whereby seek for my eviction. Only I lost a battle, therefore it can.
So illegal, so admittedly you are possessing the land of the others.
From 1960, my lord.
Maybe land of the
1960,
others.
yes.
You filed a suit seeking declaration that you, by way of adverse possession, you have acquired title.
My lord.
That suit was decided against you.
Yes, my lord.
When?
That is in the month of June 2024.
June 2020.
24.
According to you, thereafter the Tahsildar are trying to.
Tahsildar issued an order, my lord. Whether he can issue an order saying that you lost the case, therefore you have to evict. Where from he got the power? My lord, if I lose a suit, if suppose I have filed a suit for possessory right, I lose a suit of possessory right, unless and until
But
the owner.
whether Tahsildar has no power to initiate a proceedings under 161.
161, only he can initiate a proceeding when a person is dispossessed from the land within 2 years. The power the Tahsildar accrued is when a person is dispossessed within a period of 2 years, then he accrued the power. Section 161 clearly states.
Okay, if 2 years is elapsed, then what?
Thereafter, civil suit. That person has to file a civil suit seeking recovery of possession.
The Tahsildar is to file civil suit.
Not Tahsildar. This land belonged to a private party.
He didn't make any application.
No. My lord, Tahsildar did not accrue any power. If I am sitting in a land of other person, that person has to file a suit for eviction and recovery of possession. A decree ought to be passed. Once a decree is passed, thereafter, if I am not vacating, then an executive proceeding has to be filed before the trial court. How the Tahsildar and executive accrued a power? And the SHO, my lord, he is using his office. Both, I have made allegation against both of them. My lord, what I am asking
What
is,
is the urgency that?
well, urgency is that,
High Court is to interfere today. It is going on since long back.
no, my lord, after June.
File it, move it as
My
a
lord,
regular
subject to my
matter.
lord's acceptance, my prayer is very innocent.
Regular matter, it will be better, regular matter before the next cycle.
My lord, well, my lord, my prayer is
That
very
would be,
innocent.
because it has not been done yesterday or day before yesterday, that immediate
They are
intervention of the
My
High Court
lord,
is declared.
still I holds the land, and they are using their power, abusing their power. Still I holds the because 200 square meter already they have.
How, what interim order can be passed? It is.
Not to.
So you serve upon them, let them come before the court.
My lord.
Then the court will ask how, without following due process of law, how you are trying to evict. Either they will say, no, we are not doing it. Hey, from the land of private person, how you are trying to.
Paper are there, my lord. Tahsildar issued the order.
That would be better.
My lord, my lord.
That would be better. Otherwise, based on such, because there is no definite proof that yes, Tahsildar has OMP.
No, order is there. Tahsildar has passed an order. Tahsildar passed an order, my lord. November 2024. I am just placing that. I am just placing that page number, my lord, whereby that Tahsildar has passed an order. My lord,
Read Rule 26, second proviso is to be invoked.
My lord.
And urgency is that when the order was passed.
This order was passed in the month of November, but thereafter they are doing, my lord. My lord, continuous threat on in the month of January also, my lord, they have. My lord, the question is that Tahsildar did not accrue any power to.
A petition has been received.
So what he is writing, my lord, what he is writing, he said that.
Petition is received from Ujjwal Haldar.
Yes, you have lost the case, therefore you have to vacate.
No, that is the reason he has used.
But whether he has any
maybe one
jurisdiction,
person, but he is not done it suo moto.
Whether he has.
He is doing it based on a petition filed by the actual owner of the land.
Jurisdiction.
They file it in the regular.